We spent nearly a year going back and forth, hoping to get that final piece of the puzzle signed so the will could be accepted. Eventually, we had to give up.
Hi, this is Jeff Marsacci, the Plain English Attorney, and welcome to the video. Before we dig into today's topic, please help us get out solid, accurate information on estate planning and Medicaid planning by liking the video and subscribing to the channel. Unfortunately, the algorithms just tend to favor videos that tell people what they want to hear instead of what is actually true. If you want us to get the truth out there about estate and Medicaid planning information, then please like the video and subscribe to the channel.
Today, we're going to talk about the high cost of a do-it-yourself plan. There's no shortage of websites offering free or low-cost estate planning documents. Download a form, fill in a few blanks, get it signed, and you're done, right? Not quite. While it might seem like a smart way to save money, do-it-yourself estate planning can end up costing your loved ones far more in time, money, and stress than you ever imagined. Unfortunately, we see this play out in real life more often than we'd like. One of our clients recently had to deal with the fallout from a parent's do-it-yourself estate plan. The parent had used a downloaded last will and testament form. The document at first glance looked like everything was in order. The document had the basic language that you'd expect in a will. It was signed by the parent, witnessed by two people, and even notarized. But one small omission made all of the difference. In North Carolina, a properly executed will can be self-proving, which means that the probate court will accept it without needing to track down the witnesses after the person has passed away and verify that they signed that will. But for that to work, the notarization must affirm not just the signature of the person making the will, it must also affirm the witnesses signed it in the testator's presence under oath. In this case, the notarization block only acknowledged the signature of the parent, the testator, and not the witnesses. That tiny technical detail meant the will was not self-proving, and since the court had no affidavits from the witnesses, it wasn't enough to admit the will to probate on its own. After the parent passed, we immediately got one of the witnesses to sign that required affidavit. But the second witness kept rescheduling or canceling. Sometimes they were out of town. Other times they weren't feeling well. Oh, they simply didn't show up for the appointment just to come to our office to sign it, and we would notarize it for them. We spent nearly a year going back and forth, hoping to get that final piece of the puzzle signed so the will could be accepted. Eventually, we had to give up. With only one witness affidavit, the court could not accept the will. The state had to be submitted as intestate, meaning the parent was treated as if they didn't have a will at all. This wasn't just a procedural headache. It changed everything. Someone who had been specifically left out of the will suddenly became entitled to a significant portion of the estate simply because they were an heir under intestacy law. The parents' clear wishes were ignored, all because a few lines of legal language were missing from a notarization block. Estate planning isn't just about writing down who gets what. It's a legal process governed by strict rules, especially when it comes to the execution of documents.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Courts aren't in the business of assuming what someone meant. If the paperwork doesn't comply exactly with the legal requirements, it might as well not exist at all. And when things go wrong, the people left to deal with the mess are your family members, the very people you were trying to protect. A professionally prepared estate plan ensures that the documents not only reflect your wishes, but also meet all of those legal requirements so they work when that they are needed. That peace of mind is worth far more than the few dollars you might save by using a template that you found online. Don't let a technicality derail your entire estate plan. If you want to make sure that everything is done right, we're here to help. If you are a North Carolina resident and don't have an estate plan, then please contact our office at 919-844-7993 to schedule a discovery call and take the first step towards protecting your family the right way. If you are an existing client and you need to update your own plan and make sure everything is squared away, then please call the office and schedule your annual review meeting. And if you're not in the state or you just want some good information to get started on your own estate planning journey, then check out the materials at freetrustcourse.com. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.